are in.
Oh yes, I got
on video
that
camera.
part. I'm sorry. Yes,
Right.
yes,
So do you want to do this on YouTube and make
yes,
it public? Okay.
yes. We can
Then,
proceed.
all
Yes.
right, Patricia, plus put this proceeding on YouTube, please.
Yes. Lithium, cyprexa. That's the only ones I know for. Me? No.
Okay, Judge, it's on.
12.
Very good. Then we're proceeding on case
Yes.
number 549370, State versus Uziel Munoz.
Learning.
Mr. Freilich, you
Yes, Your
filed a
Honor.
motion
No.
regarding speedy trial. It's your motion. You may proceed.
Judge, we'd ask that you take judicial notice of the court's file and
No.
and everything therein.
No. Was there anything else? I've seen one, but it's recently. It's been a long time. It's been years.
Anything particular to which you refer, sir?
Yes, Your Honor. The constitutional and statutory motion for speedy trial was filed most recently. That was filed in November 11th. However, prior motions I would like to draw the court's attention to include the defendant's assertion of the right to speedy trial, which was filed on October 28th. And more specifically, the request for discovery that was filed on January 23rd, 2019. And contained in that motion for discovery is also an assertion to the right of speedy trial, wherein that January 22nd, 2019 motion, the defendant asserts his right to a speedy trial as guaranteed by the Sixth Amendment of the United States Constitution. And of course, goes on to say the criminal defendant requests an immediate and speedy trial in the above entitled and numbered cause. That was filed January 23rd, 2019. Would also draw the court's attention to the stipulated date of the offense, which is January 12th, 2017. Hey, Uziel, could you mute yourself?
I beg pardon? Oh.
I would do that.
Judge, I was asking Mr. Cruz to mute himself because I think that's where the background noise is coming from.
Yes. Did that help?
No, because I can still hear you.
I had, but I don't know.
Well, you know what, Uziel, just hang on for a second because the other thing, real quick, Judge, is we're going to stipulate that my client is in custody on other charges, other felony charges. I'm counting 1, 2, 3, 4, 5, 6 other felony charges in which he is in jail and on bond for. And we'll stipulate that he has been charged with each one of those offenses after the date of the offense here. The dates include May 2019, January 2020, and August 25th, 2020. So we'll stipulate that he is charged with those. And that's important because I'm going to call my client to testify. And we would like to specifically limit the scope of his testimony to just this charge. Your Honor, also, I don't represent him on those charges. So we feel it would be inappropriate for him to be questioned about those charges. We'll stipulate that those charges exist. We'll stipulate that he is in custody on those charges. And so we'd like to limit the scope of the cross-examination for this hearing just to this particular charge and the delay.
I presume the state has no objection.
Presume correctly, Your Honor.
All right. So for the record, that the request to limit testimony is granted.
All right. At this time, Judge, we call it Uziel Munoz Cruz.
I also have to note, or for the record, indicate that I do take judicial notice of the motions that you have filed presuming, of course, that as an officer of the court, what you're telling me is accurate.
Yes, Your Honor. There is one other thing that I believe is reflected on my notes, but I cannot, I won't give you with 100% certainty. I believe Mr. Edelman may have this in front of him. I have on my notes that August 14th, 2019, there's a state not ready. But that's the only state or defense note that I have on my file. So whereas I do have that August 14th, 2019 is a state not ready, I can't tell you whether or not there have been other readies or not readies or state resets on this case because I don't have it in front of me. So in other words, I'd like the court to take judicial notice of that state not ready on that date.
Patty, is that reflected on the file?
Judge, I don't know. I don't have that.
Okay.
I mean, I can look at the D page and see if it states on there.
Well, we'll use that. We'll leave that unspecified at this time, particularly since Mr. Freilich does not indicate with any certainty. But I have no reason
Some
to doubt it,
certainty.
but I'm not gonna presume that at this time.
Okay.
Now, Mr. Freilich, you may
Yes, Your Honor.
you may proceed with your motion.
Okay.
Do you have another motion besides this speedy trial motion?
Not at this time, Your Honor.
All right, you may proceed.
I believe Mr. Uziel Munoz Cruz is under oath. Is that correct, Your Honor?
Yes, he is.
I'd like to ask him a few questions. Mr. Cruz, if you could unmute yourself and just state your name for the record.
Uziel Munoz.
And you are the defendant in this case, is that correct?
Yes, sir.
And how long have you been incarcerated most recently?
I believe it's not 3 months already. It's going on 3 months.
Okay. And previously, you were the same person. The offense date. Do you know when the offense date was in this case? The evading? No. Since 2017, have you experienced a head injury?
Yes. Well, I was in a lot of trauma.
Can you tell the court more specifically about that trauma?
My 5 months ago, I was shot outside my house.
And since you were shot, what sort of trauma did that incur? Where were you shot?
And my side, on my left side.
Were you in?
Yes.
Were you in surgery?
Yes, I was in open heart surgery. I died twice. They had to bring me back twice. It was due to they attempted to steal my truck, and I came outside the house.
And due to that trauma and the surgeries following, has that had any impact on your mental abilities?
Very, very much, yes.
Can you tell the court more about that impact?
I can have a struggle to speech. I have a follow-up treatment that I have not been able to get due to me being here.
Say that again.
Follow-up treatment that I have not been able to get due to being incarcerated. And I'm learning my ABCs, all that back, like especially all this computer stuff, everything. I can't get medical help in the jail because everything is run through this computer stuff.
But specifically, when it comes to your ability to think and remember things, has it made it difficult for you to communicate?
Yes, yes,
Has it made it difficult for you to remember certain things?
a lot.
Can you be more
Like
specific in terms of
like
your memory?
ABCs. I had to relearn all that back, getting back the numbers, all that stuff like a kid back, like I was just born again.
Ha- has it impacted your memory in terms of certain events?
Yes, yes, a lot of stuff.
Do you have any recollection or can you remember anything about this evading case?
No,
Do you remember anything about July 12th, 2017?
no,
If did you have sorry, let me rephrase the question. Did you have the memory about July 12th, 2017 in this evading case before that shooting incident?
yes, yes,
Due to the delay, because it's taken so long for this case to go to trial, is it difficult for you to discuss this specific incident with your attorney?
yes,
And that's going to make this case very difficult for you to testify about.
correct.
I think that's it, Judge. Pass the witness.
Mr. Edelman,
Mr. Munoz, with your memory deficits, I understand if it will be difficult for you to answer certain questions that I will ask. If you don't remember something, please say so. So you were initially arrested for this offense on July 12th of 2017, is that correct?
I don't remember the date exactly.
Fair enough. Do you remember when your first court setting was?
No.
Well, the court has already taken judicial notice of the court's file, and the court's file will show that your first pretrial conference occurred on August 3rd of 2017. At that point, did you assert your right to speedy trial?
Say the question again, please.
At your first court setting, did you assert your right to speedy trial?
I wouldn't be able to tell you to answer that.
Fair enough. Do you remember how many times your case was reset before you failed to appear on July 26, 2018?
No, sir.
And then do you remember how long you were a fugitive from justice after failing to appear?
I don't remember being a fugitive.
You don't remember failing to appear on July 26th of 2018 and well, you wouldn't remember that the court issued a warrant, but you don't remember being taken into custody on or about December 14th of 2018?
No.
And then afterwards, do you remember any of the subsequent court settings that you had for this case?
All I can say, I know I had several, but I don't know exactly.
Do you remember the dates of March 20th of 2020 and January 29th of 2020?
No.
Now, do you have any witnesses to this offense who are unable to be contacted by your attorney in order to be produced in court?
What do you mean? Any witnesses for what?
Any witnesses to this offense other than you who would be able to testify for you?
What do you mean this offense?
This evading arrest or detention?
No.
Do you remember when you suffered the injuries that led to your current mental deficits?
It's months back.
6 months back?
Months back.
Can you remember how many months back?
Been here for like 3 months. So like a four or five, maybe.
And this would predate the offense date of your most recent alleged felony offenses. Is that correct?
There was felony charges.
Are you aware that you have felony charges pending?
I got them now, yes.
Are you aware of how many?
No.
Are you aware of their alleged offense dates?
Alleged offense states.
Yes, when you're alleged to have committed those offenses.
No.
Are you aware that those alleged offense dates are after the date on which you received the injuries that led to your current mental state?
Somewhat, I guess.
All right, pass the witness, Your Honor.
Nothing further at this time, Your Honor.
All right, Mr. Munoz, you can mute yourself again. Mr. Freilich, anything else?
No other evidence, Your Honor.
Mr. Edelman, any witnesses or testimony?
No, Your Honor.
All right, argument. Mr. Freilich, it's your motion.
Judge, this is a due process argument and a motion to dismiss for lack of a speedy trial. Our specific argument is that under Barker-Wingo, there has been a significant delay since July of 2017. I mean, we're talking about at least 3 years. The reason for that delay, obviously we have a state not ready and some other things that are issues there. We have asserted our right to a speedy trial consistently for the past 18 to 20 months since January of 2019. And finally, the prejudice we've suffered, I think, weighs most heavily against the state. But besides that, Judge, I think when we're weighing things against the state or against the defense, what we're faced with at this time is our due process argument that because of that delay, we are unable to prepare a defense. My client does not have any recollection of the incident that took place. I can't defend someone if I can't talk to him about this offense. Because of the 3-year delay between July of 2017 and July 2020, that's a 3-year delay. And then my client has lost his mental capacity. And as you can tell from the testimony and cross-examination, my client does not have the mental capacity to defend himself, to communicate with his attorney, to testify about the events of that day, and provide any possible defenses. And so that due process argument is because of the delay, we are unable to prepare a defense. It's not, and if we go through the Barker-Wingo factors, that 3-year delay can be attributed to the court as well as to the state. And with all due respect, Your Honor, that delay from my client has resulted in the inability to defend himself even if we were granted a trial And even if you did not find there was a violation of his constitutional rights and we just gave him a trial, as we've been asserting for the past 18 months, that trial, we are unable to defend him because of his mental capacity. So what we're saying is due to the speedy trial violation, the only possible remedy is a dismissal. Because of the 3.5-year delay, because of the situation that we now find ourselves in, regardless of whether my client was a fugitive, regardless of the fact, for a brief period of time, and regardless of the fact that we've only asserted for the past 2 years, more or less, at the present time, we have gotten so far past the speedy trial that we've asked for that the due process concerns are that he cannot properly communicate with me and properly communicate with the jury to defend himself. And therefore, the only remedy we see fit is a dismissal. Now, I know I'm not going strictly by the Barker-Wingo factors, but I believe in this case, Your Honor, that due process argument should overweigh any particular deficiencies we have in any particular prong of the Barker-Wingo factors. Due to his being shot and his mental capacity, I can't defend him. And all of that combined together should overweigh, with his constitutional rights, any concerns by the state. And here's my point, is he has a constitutional right to a speedy trial and a constitutional right to due process, both of which are being violated. And there's nothing that we can do, and there's nothing the court can do to remedy that situation. Because of that delay, because of the 3-year delay, because of it's been this long since the assertion, because of the reason for that, again with the state not ready, again with the multiple resets by the court, that it becomes impossible to overcome those due to the significant prejudice my client has suffered. And again, you've heard him testify. You've heard him, before we even got on the YouTube, go through and those specific questions he was being asked. He has a hard time answering that. He's having a hard time learning his ABCs. That significant prejudice, because of the 3-year delay before he was shot, should overwhelm any one particular aspect of the Barker-Wingo factors and weigh heavily in my client's favor in terms of a dismissal, just because it becomes impossible to defend someone who's in that condition due to the delay. And for that reason, Judge, we'd ask for a dismissal in this case.
Anything else?
We'd save time for rebuttal.
Mr. Ailman.
Your Honor, the defense has made a very good argument that Mr. Ucio Munoz is incompetent to stand trial because he lacks sufficient present ability to consult with his attorney with a reasonable degree of rational understanding. Defense has made a very poor argument that this case should be dismissed for violation of speedy trial. And you can come to that conclusion for a number of reasons. You can come to that conclusion based off of the defendant's complicity in the length of the delay. The court earlier took judicial notice of the fact of the file, and so the court has ample awareness of the number of resets, both prior to Mr. Ucio Munoz's failure to appear in this case, subsequent to his failure to appear, being taken into custody. And that's something that I really want to draw the court's attention to. Mr. Munoz Cruz, and I apologize for stating his name incorrectly, was rearrested for this offense on December 14th of 2018. He then had pretrial conferences on February 8th of 2019, March 19th of 2019, April 1st of 2019, June 4th of 2019. Then had his first trial setting on August 4th of 2019. This was the first not ready by the state. That was followed by subsequent trial settings on January 29th and March 20th, both of which were agreed to, which indicates that the defense was in agreement to the fact of the resets, rather than in opposition to them. So, despite what defense counsel presents as Mr. Munoz Cruz's assertion of his right to speedy trial, his first assertion of the right doesn't occur until January 1st of 2019, nearly a year and a half after the alleged offense. And then even after this assertion of his rights, you have another 7 months of pretrial conferences in which, as far as I can tell, nothing is accomplished towards the production of evidence or witnesses that would assist Mr. Munoz Cruz. And even after that, when the cases are actually set for trial, you have multiple incidences in which the defense agrees rather than argues against resets of this case. So, at multiple instances along the course of these proceedings, the defendant has been complicit in lengthening the delay, which weighs in favor of the state, because the state is not purely responsible or even largely responsible for the number of delays that have occurred. Moreover, when measuring the prejudice to the defense in terms of the defendant's ability to recall elements of the offense are unfortunate. However, Mr. Munoz Cruz has also not indicated that he would take the stand to testify in his own defense. And without any indication of that, then Mr. Munoz Cruz's memory deficits are irrelevant. If he's not going to testify in his own defense, then what evidence is he going
I need to object to that, Judge. He's commenting on my client's constitutional right to remain silent in terms of a trial that hasn't been set. So with the comments on his right to remain silent, we would object to those.
Well, it's to the court.
Whether it's to the court or the jury, it's still improper. I believe that my client will or may have his right to remain silent intact,
Well,
just
he
as
will.
though we can't comment on his ability to waive a jury, or we can't comment on his ability to any one of his other rights. I think that whether that comes up or not is irrelevant. I believe that what we're talking about is the delay and the speedy trial rights, and not whether or not he potentially could waive his constitutional right to remain silent or assert his constitutional right to remain silent.
I'll go ahead and sustain the objection. It's I've already heard it anyway. Since it's not to a jury, it's not going to be prejudicial. But I do sustain the objection.
Well, Your Honor, if there's a way for me to withdraw the question, then I would like to. But I think the court understands the general thrust of the state's arguments. Mr. Munoz Cruz is not in jail presently because of anything related to this offense. He's in jail because he is alleged to have committed multiple felonies while awaiting the adjudication of this case. And so any prejudice that he is suffering as a result of the pendency of this case is not actually a result of the pendency of this case. It's a result of the multiplicity of offenses that he is accused of committing. So the defense has not demonstrated that the state is responsible for the delay in this case. The defense has not demonstrated that the delay that has occurred has actually prejudiced the defendant in a substantial fashion as far as the state is concerned. And because of those failures of the defense in this motion, the state believes that the motion should be denied. Now, the state does believe that if the motion is denied, that Mr. Munoz Cruz should be evaluated for competency to stand trial, because with
That he should what? I'm sorry, I'm having it. You do believe?
And Judge, I'll object to this as well. It's outside the scope of the hearing. What happens after this case, if the motion is denied, is irrelevant.
What were you addressing, Mr. Edelman? I thought you were
Judge, he might as well be arguing that after the motion is denied, that my client will go on and commit more felonies.
Mr. Fraley, just wait up a second. Mr. Edelman, what aspect of the defense presentation are you referring to?
I'm referring to the defense's presentation of evidence relating to the Barker-Wingo factors of the reason for the delay and the prejudice to the defendant. In the state's estimation, those have been deficient to demonstrate the required evidentiary showings that need to be made, that the state has been responsible for the delay and that the defendant has actually suffered a prejudice because of the delay.
Right. Anything else, Mr. Edelman?
No, Your Honor.
Mr. Fraley, anything else?
Judge, I wanted to really rebut a couple of things. One, what happens if you deny the motion is completely irrelevant to what we're presenting. The presentation should be strictly limited on whether my client's constitutional rights have been violated. The client has a constitutional right to a speedy trial. That's been violated by the 3.5-year delay. We go through the factors. There are certain significant things that I can discuss with the specific incidents of that, but the point remains, as a broad spectrum, my client's rights have been violated. Speedy trial rights, due process rights. He has never wavered in those constitutional rights. He will always have the constitutional rights to speedy trial and to due process. Specifically in regards to the due process rights, Judge, his inability to provide a defense makes it impossible due to the delay in the speedy trial. Those two things go hand in hand. What we're arguing here is that his rights have been violated and there are no other alternatives but to dismiss the case. What happens after the case is dismissed, if you want to go that way, he's still incarcerated and he'll continue to suffer prejudice in terms of the felony cases. But Judge, our argument is, for 3 years he was awaiting trial. He has now lost the ability to defend himself. He has no way to defend himself because of the delay, which can be attributed to the state. They have a burden to bring the client to trial. The client does not have a burden to bring himself to trial. Okay? If we eliminate the part where he was bond forfeited, that's fine. We still have 18 months, which we've been asserting our right to a trial. And finally, Judge, the last thing, I don't recall agreeing to resets. I've been defending Mr. Munoz Cruz since the beginning, I believe, and I don't recall agreeing to resets. I don't believe that was specifically introduced into evidence, although it might be in the court's file, of which we're going to ask Patty to look at. But Judge, we have to get back to the main point. My client, even during a pandemic, has constitutional rights. We are asserting his constitutional rights. He is being denied and has suffered because of the denial of his constitutional right to a speedy trial and to due process, and therefore there's no other option but to dismiss this case, and that's what we'd rely on.
I am troubled, Mr. Fraley, by the fact that there's appears to be a significant amount of delay that was brought on by the defendant. I have not seen or heard evidence to the contrary. It appears that he was a FTA, and how much of the time, neither side has clarified for the court how much of the time or how much of the delay was due to his own absence, willful absence, I don't know. Absent those factors at this point, I'm not going to rule in favor, but I do want to look at the file since I have taken judicial notice of it. I guess I should want to know what's in it that I took judicial notice of. I'm not certain that it is the state's delay. Second, there's a secondary part too. The delay itself does not cause the loss of ability to provide a defense. The delay exists, but the delay did not cause the lack of ability to assist and provide a defense. That was a result of intervening factors, specifically his being shot by some third party or parties. The delay does not cause his loss of memory. Ordinarily, you could say that it may have, that it did, but from what the testimony of the defendant was that he had to even relearn his ABCs. That's not a delay. That's not the result of a delay. That's a result of trauma. And in fact, the defense specifically referred to his trauma.
Your Honor, I'm sorry to interrupt, but I believe that Mr. Freilich has a response to the court's statements, and if the court will allow Mr. Freilich to address those.
Number of them, Judge, but didn't want to interrupt.
Go ahead.
One, we would ask the court, upon reviewing the file, to look for two specific things. One, whether there's evidence of agreed resets by the defendant's attorney acquiescing to those resets, and whether that there is evidence of that exists in the court's file.
All right.
And secondly, Judge, we'd ask that how much delay exists after subtracting the delays that can be attributed to the defendant. With a 3.5-year delay, Judge, by my math, even if we take out the point in time before the first assertion, which is January of 2019, we still have over 20 months where we have, since we've asserted our right to a trial. So even if we do some math and take away the first, let's say, 2 years of this case and attribute that solely to the defendant, which of course we don't, but even if we do, we are still left with, coming up on January 2021, the soonest we could get a jury trial, we're talking about a 2-year delay still.
We're looking at, by the way, April for jury trials. So that compounds what you're saying. I understand.
What I'm getting at is, even if we subtract delays attributable to the defendant, we still have that. So I would like the court to, again, when you're reviewing the court's file, to probably do what you and I are probably not used to doing, which is math, and going towards that and kind of do that.
All right.
My apologies.
Those will be the two matters that I'll be looking at.
And last, Judge, what the one thing I was going to wait until, just one additional thing is the reason that we brought up that delay is if we had gone to trial in this case in a reasonable time, we would not have the issues we have now. And that's why it becomes a speedy trial argument. Is that prejudice that's been suffered is due to the delay, because if we had tried this case in a timely fashion, as my client's constitutional rights suggest, we wouldn't have the issue of the head injury. Okay. That's where it comes into factor. It's just the prejudice he'd suffered because of the delay. And so for some folks, that's anxiety. And that's the things that we're used to dealing with. Anxiety, being locked up, those things that we're used to dealing with, those won't be issues except for the delay. Same thing in this case.
I hear what you're saying.
Okay.
All right. Excuse me. The court's going to take this in consideration. I will look at those three things. And Patty, let's reset this for 1 week. I realize we got Thanksgiving in between, but I want to look at these issues and see where we're at. And
Judge, if we don't need a setting, if you can, I'm sure Mr. Letterman has discussed before, has his laptop on him sometimes. If you want to email a response or anything, and I can relay any things to my client. I know certain things do have to be on the record, but due to the Thanksgiving, if you do have the opportunity to reach a conclusion to something, I'm more than happy to arrange a meeting with my client to relay any things, questions or things like that to him if it doesn't need a setting.
All right. Very good. Then anything else, Mr. Edelman?
A few other things. However, this is the defendant's motion, and I believe the order of argument entitles him to open and to close. And unless we want to get into an endless tit for tat, I think we need to bring this to a close at some point.
Excuse me, Andrew, I'm having a little hard time hearing you.
Which one?
Mr. Edelman.
Yeah, I figured. Do you need me to repeat my last statement?
Let's see. I heard you say I don't want to get into tit for tat.
Unless we want to get into an endless tit for tat, then we need to stop somewhere. So I'll refrain from making any other comments.
And Judge, before we go off the record, I have one additional thing.
I'm listening.
Because my client is in custody, we'd ask that and I know it sounds strange, Uziel, and I'll explain this to you later. We want to make sure he gets credit for all the time because he's currently on bond in this case. We want to make sure he gets credit for all the time he's in bondage. So the ask then would be for you to maybe increase his bond so that he can start getting some credit for this too.
Patty, what's his current bond?
Judge, on November 12th, you increased his bond to $3,200, and he is currently listed at Bexar County Jail since November 12th.
Sorry, I didn't know that since November 12th. Okay, I just want to make sure. And of course, Judge, he has been incarcerated for longer than that, so we'll ask that he be given credit for that time at a later date.
All right, just remember to bring it up later on.
Yes, sir.
If necessary. All right.
I do have one last comment to make. Based off of the evidence introduced during the hearing, the state believes that there may be a competency issue in this case, and the state would recommend that Mr. Munoz Cruz be evaluated for present competency.
All right. Patricia, the court orders a competency evaluation in reference to the defendant's competency to stand trial on this specific issue, this specific case.
Yes, sir. I'll get Linda to draw up that order for you.
Very good. All righty. Then Andrew Freilich, have a good Thanksgiving, you and your loved ones.
Judge, I got the hearing right after this too, so I'm just going to excuse myself for a moment, and I'll be right back.
Okay. What time we have the next one, Patty?
At 10:30, Judge, in 2 minutes.
Okay, very good. Mr.
Patty, can you make
Munoz?
sure Mr. Green, not the
there.
Mr. Green?
Yeah, he's waiting.
Okay.
All right, Mr. Munoz, you're excused. Take care. What do we have in Mr. Green?
I believe,
The
Your Honor,
next-
Go ahead, Patty.
The next hearing is on Christopher Michael Green, as in the color. It's,
Case number.
641-135.
Christopher Michael Green. Purpose of the hearing.
It's 2 motions. His offense is ABI.
All righty. Date. Or
Date of the
dates.
offense, sir?
Date of offense,
The alleged offense date is July 5th of 2019.
July 5th, 19.
Yes, sir.
Both of them same date?
There's only one offense, sir.
Okay.
I am back.
And what are the motions?
Oh, me, Judge?
Yeah.
Same thing, speedy trial dismissal.
All right, speedy trial, and what's the second one? I was told there's two motions.
Really? Speedy trial?
I was told there are two motions you filed that we were hearing.
I mean, the first one might have been an assertion, the second one the dismissal, Judge.
Defense counsel is correct, Your Honor.
Okay, so it's actually one motion per se. All right. Defense, you ready?
Judge,
Yes?
we're still on YouTube. Did you want me to